Hello, my name is Alex Proctor. I'm the Chief Trust and Privacy Officer at Captain Compliance. This video is focused on the topic of cookie consent management. I'll tell you right now, this is an interesting and evolving aspect of modern privacy. It comes with lots of nuances and even some common misconceptions. Whether you manage a large corporate website or a small online shop, you may be wondering if a cookie banner and cookie consent management capability is necessary or otherwise sensible for your website. You may also have logistical questions, like whether it makes more sense to adopt a universal approach around the world or to tailor cookie consent practices regionally. My goal is to share information and insights to help you with these sorts of questions. To start, I'll spend a few minutes explaining what cookies are, why consent banners exist, and what they need to accomplish. This will help set the stage for the broader discussion. We'll then examine the global landscape, focusing primarily on the differences between opt-in and opt-out consent requirements. We'll use Europe and the United States as our points of reference. Finally, we'll revisit the central question, do I need a cookie banner? And consider it along with other important questions from the perspectives of privacy compliance, risk management, and customer trust. Before we jump in, I'd like to share a couple of quick disclaimers. The first is that cookie consent has legal implications, and as such, decision-making about cookie consent should involve your legal team. Second, I represent Captain Compliance, a privacy technology company with a cookie consent management solution. Our platform won't be the focus of this video, but just be aware that we're here to help if you're looking for a robust cookie consent solution. I'll share contact information and details in the video description. All right, that's enough of an introduction. Let's dive into the world of cookie consent. Let's start with the basics. What exactly are cookies? Cookies are small files that are stored on your device by websites that you visit. Cookies are generally helpful in delivering a personalized, efficient web browsing experience, and they can also provide businesses with valuable insights and analytics into their website traffic. However, cookies also have privacy implications because they can be used to track your online activities, including for targeted advertising. Given the wide-ranging nature of cookies, it's important to understand a couple of basic ways in which they can be categorized. First, there are first-party cookies and there are third-party cookies. The difference is that first-party cookies are placed on your device by the specific website that you are visiting, while third-party cookies are set by another party, such as an advertiser. Cookies can also be session-based, meaning that they only last as long as your browser session is active, or persistent, meaning that they remain on your device until they're deleted or they expire after a certain period of time. Now, additionally, cookies can also be categorized by their purpose. The first category to consider is what's called strictly necessary or essential cookies. As the name implies, these cookies are essential for supporting a website's core features. A common example of a strictly necessary cookie might be a cookie that supports a website's shopping cart functionality. Strictly necessary cookies are quite important to understand for cookie consent because, generally speaking, it doesn't make sense to give visitors choices about whether or not they're used. This is because they need to run in order for the website to work. Another category is called performance or statistics cookies. These cookies collect anonymous information about how people use a website. For example, they might help identify which pages are visited most frequently or how links are used. As you might imagine, performance cookies can help improve and optimize websites. Next, we have functionality or preference cookies. These cookies remember your personal choices or details on a website, such as your login credentials or your preferred language. They can also help customize other aspects of your experience on the website, potentially involving things like the text size or layout. Finally, there are targeting or marketing cookies. These cookies collect information about your browsing activity, preferences, or geography. This information can be used to serve you personalized advertisements that are relevant specifically to your interests. These are usually persistent, third-party cookies set by advertising networks with the website's permission. Targeting cookies are the most notable cookies when it comes to privacy. And practically speaking, they're also the most important to understand when it comes to cookie consent management. Let's move on to that concept of cookie consent. Cookie consent is the process of obtaining a user's permission before placing cookies, or perhaps more specifically, certain types of cookies on their device. In practice, you'll often see cookie consent implemented using cookie banners on websites, directly prompting users to either accept or reject the use of non-essential cookies. From there, the cookie banners are supposed to respect the privacy preferences of the visitor. Now, you will see many different flavors of cookie banners in the wild. Right or wrong, they can vary a lot in their look and feel, the type of notice they provide, and the actual options that they give you as the website visitor. This concept of cookie consent is rooted in the fundamental idea that individuals have a right to know and control how their personal information is collected and used online. With that said, one of the main reasons that cookie consent is important is that it can be necessary to comply with various privacy laws and regulations that have been enacted around the world. It's important to understand that cookies are often in scope for these laws. If a cookie can identify you or track your online activity, either alone or combined with other data, it will qualify as a form of personal data under most privacy laws. This is particularly true for third-party cookies used in advertising, as they often rely on identifiers like IP addresses and device IDs to build a profile of your online behavior. I'm going to take a few minutes to describe this current legal landscape. I will warn you that this is just one of the topics where details matter a lot, so I'll be sharing a fair amount of information here. As with many other privacy topics, it makes sense to start this part of the discussion in Europe, home to some of the world's strictest privacy laws. You may be familiar with the General Data Protection Regulation, or the GDPR in the European Union. It's thought of as the world's most significant privacy law, and many other laws have been modeled after it. What you may be surprised to learn is that the GDPR itself doesn't devote much specific guidance to cookies or cookie consent. There is exactly one mention of cookies in the GDPR, and that single reference essentially clarifies that cookies can, under some circumstances, be considered a type of personal data, and as such, fall within the scope of the GDPR. Quite literally, that's it as far as the GDPR goes. Now, with that said, the EU also has something called the e-privacy directive. The e-privacy directive predates the GDPR. It was originally passed in 2002 and was amended 7 years later. You'll sometimes hear this referred to as the cookie law, or some variation thereof. This title may be a little misleading. The directive is not focused entirely on cookies, but it does outline several specific cookie consent requirements. One important aspect of the e-privacy directive is that companies need to receive user consent before any non-essential cookies are used on websites. They also need to document and store consent records. I want to draw attention to the fact that the e-privacy directive requires the use of an explicit opt-in model for cookies and tracking. Again, this means that website visitors need to explicitly opt in to tracking before non-essential cookies are used. This is a very important point of contrast with some of the other laws around the world which do not share this requirement. In addition to requiring user consent, the e-privacy directive includes several additional cookie-related requirements for companies and their websites. For one, companies need to provide clear and comprehensive information about the types of cookies used on a website, along with their purposes. This information must be presented in an easily accessible manner, potentially through a cookie policy, privacy notice, or cookie transparency page. The e-privacy directive also emphasizes the importance of user control. Users must have the ability to withdraw their consent just as easily as it was given. And website operators are required to provide mechanisms for users to manage their cookie preferences at any time. It's also notable that companies must allow users to access their services even if they do not choose to allow the use of certain non-essential cookies. Finally, it's worth noting that the e-privacy directive is in the process of being replaced by a proposed e-privacy regulation, which aims to provide a more updated and comprehensive framework that aligns closely with the GDPR. The main thing to know is that the proposed regulation contains simpler, streamlined rules surrounding cookie consent. With that said, the e-privacy regulation is already several years behind its anticipated schedule, and at this point, it's still a proposal. So, that's the situation in Europe. It's an excellent example of a region demanding an aggressive opt-in cookie consent approach. Now, let's turn our attention to the United States. Unlike the European Union's e-privacy directive and the GDPR, the United States does not have a single comprehensive federal law governing consumer privacy. Instead, privacy regulations are extremely fragmented. Businesses operating in the US face a complex and evolving landscape. In the absence of comprehensive federal regulation, several states have taken the lead in creating comprehensive privacy laws that have major implications on cookie consent management. California was the first prominent example, so it's a good place to start exploring the US privacy landscape from. The California Consumer Privacy Act, or CCPA, and more specifically its amended version, the California Privacy Rights Act, or CPRA, is considered to be the most comprehensive state-level privacy law in the US. It deals with many different privacy-related issues and requirements, many of which relate to cookie consent. The first thing to know about the CPRA is that it's based on an opt-out consent model. Californian residents have a formal and specific right to opt out of the sharing and sale of personal information to third parties. This means that, from the perspective of the data subject, imagine the person in California visiting your website, there needs to be a mechanism to opt out of non-essential cookie usage, because the use of targeting cookies in particular can qualify as the sharing and sale of personal data. There's a really important point of contrast here. Notice that the CPRA is opt-out, while in contrast, the EU's GDPR and e-privacy directive require an opt-in model. This detail has logistical and technical implications on how cookie consent should be handled in each region. We'll get into the differences a bit later and why it often makes sense to have cookie banners behave differently depending on the local laws. In addition to establishing an opt-out consent model, the CPRA also requires companies to post a notice on their website that says, "Do not sell or share my personal information." Interacting with this link should allow visitors to submit an opt-out request, which should influence the use of targeting cookies and potentially more. One last comment on California. This is one of two states that currently require companies to support GPC signals. GPC stands for Global Privacy Control. It's probably the most prevalent technical standard for automated privacy opt-outs, and it's consumer activated. It can be turned on directly in the browser, and for browsers that don't support it natively, through a special extension. The GPC signal simply tells websites what a visitor's preferences are. Think of it like an automated way for visitors to interact with cookie banners. Privacy-conscious individuals will typically use this to automate their rejection of non-essential cookies. Anyway, this is important to know because it may not be practical or possible to respect GPC signals and user preferences without a cookie consent management capability. Now that you know a little bit about the US's first comprehensive privacy law, let's talk about what's happened elsewhere in the US. California passed the CCPA, which was the original iteration of their privacy law, in 2018. It went into effect in 2020. Since that time, approximately 20 states have passed or fully enacted their own privacy laws. The individual state laws which have been passed are generally similar, but they also tend to have their own unique nuances. I don't have time to talk about every law in this video, so instead, I'm going to summarize areas that tend to be similar between the laws, as well as areas that differ with respect to cookie consent management and the potential implications on your cookie banner practices. One of the common themes between all of the currently established state laws is that they all generally establish an opt-out consent model. Much like California, these laws require businesses to provide data subjects with the opportunity to opt out of personal data processing, especially for the purposes of selling or sharing information. Now, there are exceptions to this. You will generally find that processing sensitive data or children's data require opt-in consent for processing under these US state laws. However, as a general statement and rule of thumb on cookie consent, we're looking at opt-out requirements. Now, Let's go over some state-level differences that impact cookie consent. First, the states tend to have different thresholds for applicability. Some laws, like California, Tennessee, and Utah's, have a minimum revenue component. Others activate based on the number of consumers for which personal data is processed. Usually, this minimum threshold is significantly lower if the company is making a substantial amount of revenue from the sale of personal data. You'll want to check out the thresholds in each state that you operate in as you make privacy risk decisions. There's also at least 2 states that have a totally different way to establish applicability. Texas and Nebraska don't have any sort of revenue threshold or consumer thresholds. It's also worth mentioning that maximum fines and penalties can differ between the states. In most states, the maximum penalty per violation is $7,500. Several states then ramp up the penalties for repeat violations. There are also states with even higher penalties. Maryland, for example, has set their standard at $10,000 per violation and then $25,000 for each subsequent violation. Keep in mind, all of these violations can add up if many data subjects are involved in one instance of noncompliance. I'll share a few more quick differences between the state laws. Some states have specific requirements surrounding opt-out links and text, some don't. Around half of the states require universal opt-out recognition, or more specifically, the honoring of GPC signals. The rest don't explicitly require this. Another important difference is that the state laws don't always define the sale of information in the same way. In some states, a sale applies to a monetary transaction only. In others, a sale can occur if there's some non-monetary exchange of value. This is actually very applicable to cookie consent because it can potentially bring third-party targeting cookies into the scope of a sale. In turn, this can activate certain aspects of the law when it comes to cookie practices. A final difference has to do with the concept of cure periods. Several states allow companies a short-term cure period to address violations. In a lot of these cases, the concept of a cure period is scheduled to sunset. I'll give you an example. Colorado state law currently has a 60-day cure period. However, it's set to sunset on the first day of 2025. There are also some states like Rhode Island that don't have a cure period at all. The last thing I want to say about these state-level regulations is that there are 2 state privacy laws that are sort of outside of the box and different from the rest. These 2 states are Nevada and Florida. Nevada's law, which was actually passed before California's, is not considered a comprehensive privacy law because it's not as broad as the others. However, as it so happens, its more narrow focus is on websites and web services. It contains opt-out requirements, and it's relevant from a cookie consent perspective. Florida's law, which was enacted much more recently, has a very narrow scope. It's mostly applicable to big tech companies, particularly those making in excess of $1 billion in annual revenue, and also being involved in high-volume targeted advertising, smart speaker services, or app store ownership. It will probably not be relevant to you or your company unless you meet these very significant thresholds for applicability. That's enough about the US state laws. The main takeaway here is that all of these state laws currently feature an opt-out consent model. On a somewhat related note, there are efforts to pass a federal privacy law in the US. This could impact cookie consent requirements in the future. There are 2 bills on the table. The first is the American Data Privacy and Protection Act, or the ADPPA, and the second is the American Privacy Rights Act, or APRA. The APRA seems to be the successor to the ADPPA, but the 2 bills are a lot different and there's a lot of uncertainty here. As of now, we're dealing with this multifaceted landscape that I've just described. I hope that was a helpful summary of the legal side of cookie consent. There are many other countries with their own laws that are relevant. The good news is that they can be generally categorized into opt-in laws, like those of the European Union, or opt-out laws, like the US state laws. Rather than spend any more time breaking down specific regional requirements, I want to spend the rest of this video on the practical considerations surrounding cookie consent management. Let's go back to the question in the title of the video. Does your business need a cookie banner? I'm going to do my best to help you think about this question from a few perspectives. For the sake of the rest of the conversation, let's assume that your business is using non-essential cookies, particularly for things like personalized advertising and website analytics. Let's also assume that your organization wants to continue to use these types of technologies in a compliant way and with appropriate guardrails in place. Let's start by thinking of this from a geographical perspective. First of all, if your business operates or targets consumers in the EU or other strict opt-in regions around the world, you're almost certainly going to want to have a cookie consent solution, including a cookie banner which allows your website visitors to opt in to non-essential cookie processing. There are some trade-offs here, which we'll get to shortly, but at the end of the day, the laws in these opt-in regions are aggressive, fairly unambiguous, and they may have large penalties for non-compliance. The GDPR fines can be very high, up to 10 million euros or 2% of total global turnover. Those fines can actually even double for severe violations. This can make for fairly easy decision-making when it comes to cookie consent. Now let's think about the regions that have passed opt-out laws. For the sake of example, let's focus on the individual US states and assume that your company's processing activities meet the minimum thresholds to bring the laws into play. In these jurisdictions, you can generally use cookies and tracking technologies without explicit consent. Of course, remember that there are exceptions to the rule involving sensitive data, such as when companies knowingly target children. Even so, many of these laws do require companies to provide data subjects with the option to opt out. If you don't have a cookie consent management system that can accommodate opt-out requests, you will have an extremely difficult time satisfying this requirement. You will also have a very hard time respecting GPC signals, particularly as more and more states enact requirements surrounding universal opt-out mechanisms. With all of this said, it makes sense to use a cookie consent management tool in regions that require opt-out consent models and GPC signal processing. It's safe to say that cookie consent management is directly relevant for both opt-in and opt-out regions around the globe. Now let's address a common question. I'm often asked if it makes more sense to rely on a global configuration for cookie consent technology, or if it makes more sense to create granular policies for different regions. My stance is that for most companies, it makes sense not only to have a cookie consent management solution, but also to make sure that the solution is capable of different behaviors in different regions. As a general rule of thumb, it can be problematic to take a universal approach to cookie consent around the world. If you take too light of an approach, perhaps using opt-out rules, you may end up deploying a solution that's not stringent enough for the world's most aggressive laws. Inversely, using a heavy-handed opt-in consent model around the globe may very well impact marketing and web analytics efforts in regions where you might not need to in order to comply with the law. This isn't always compelling to the business. There's no right or wrong answer here, particularly when it comes to using opt-in consent approaches broadly. It's simply a real-world challenge, and I'm just pointing out that it's really helpful to have the option to rely on different cookie banner behaviors in different regions. Now, let's talk about another challenging aspect of cookie consent. As I mentioned earlier, in the real world, you tend to see many different styles and approaches to cookie banners and notices. In my opinion, there are some misconceptions amongst companies about what actually makes for a good banner. I'll give you a couple examples. First, I see a lot of consent banners that include a privacy notice, along with a single button or option to accept the terms of the notice. This is a popular banner style, and in some unique circumstances, it might be an okay option. In others, it's clearly not a good choice. Regardless, the main point is that this is rarely going to be the best available option because it doesn't provide a clear, obvious, and equivalent opt-out mechanism. Another type of issue that can come up with cookie banners has to do with the concept of dark patterns or deceptive designs. These situations arise when banners are configured in a way that might manipulate the decision-making of the data subject. One example of a deceptive pattern would be using pre-checked checkboxes for situations that require explicit consent. As you can imagine, this doesn't meet the spirit of the privacy laws that require freely given, specific, informed, unambiguous consent. Another example of a deceptive pattern might involve the colors of accept or reject buttons on banners. For example, it could be considered deceptive to make an accept button a visually suggestive green while not doing the same for a corresponding reject button. Believe it or not, this is actually quite the hot topic in the privacy world. I'll spare you the full history, which has involved some debate. What you need to know is that doing this can qualify as a deceptive pattern. Several EU countries have specifically provided guidance that accept and reject options need to be equivalent, meaning equally accessible and easy to use quickly. There's one more angle that I want to talk about, and it's customer trust. When you're making privacy risk management decisions and deciding how to approach cookie consent, remember that it's not all about compliance. My intention is not to diminish the compliance aspect here, but rather to emphasize the importance of building customer trust, regardless of the laws. People appreciate companies that respect their privacy and treat their data carefully. They want companies to be upfront about what data they collect and why. There's a growing expectation of privacy by default, where companies minimize data collection and only use cookies when absolutely necessary, rather than automatically tracking users. As more and more comprehensive laws are passed, consumers are becoming increasingly interested and knowledgeable about their privacy rights. There is something to be said for going the extra mile, whether it's honoring data subject rights or providing consent options that may not be absolutely required in a particular region, or being very transparent about personal data processing practices and privacy and cookie notices. Using transparent cookie notices and offering clear privacy choices to your website visitors can generate serious customer goodwill and can be very rewarding in its own right. The bottom line is that people want control and respect for their privacy. They simply prefer to interact with brands that prioritize data protection and offer simple ways to opt out of tracking. All right, I think that about wraps it up. I hope that this video has given you some things to think about when it comes to cookie consent management. Like I mentioned in the beginning of the video, I represent Captain Compliance. We have a fantastic cookie consent offering, which is part of our robust privacy platform. And we have the team to address cookie consent and other practical privacy challenges head on. If you need help, please feel free to visit our website. It's captaincompliance.com. I'll put the link as well as additional contact information in the video description. Thanks again for watching, and take care of those cookies.